The defences to high-range drink driving include unsafe reading. Now, if you blow over the limit at a roadside breath test, you will then be taken back to the police station or to a booze bus for another breath test. It's called a breath analysis. Now, the evidence from that breath analysis machine is what's admissible in court, not the roadside breath test. However, it's important to know that your blood alcohol concentration can increase 40 minutes or even up to an hour or more after drinking. So your blood alcohol concentration when you drove may have been significantly lower than later, that is 40 minutes or an hour later or whatever it might have been, when you were tested at the police station. If we feel that this may have been the case, we can obtain a pharmacological report to show that the reading at the time of driving was lower than when you were later tested at the police station. If we get that report and it's positive, we can send it to police and request the withdrawal or reduction of the charge, for example from high range PCA to mid or even in some cases low range PCA. If police refuse to do this, we can fight the case in court. A second defence is called the 2-hour rule. Police must test you at the police station or booze bus within 2 hours of driving. Otherwise, the reading from the breath analysis machine will be inadmissible in court. A third defence is called the home safe rule or home safely rule. This just means that police can't test you on your own property. So if police believe that you're drunk and you've driven onto your own property, they can't just come in and give you a breath test. However, they may be able to charge you with something else instead, such as driving under the influence. A fourth defence is called honest and reasonable mistake. This is where you honestly believed that you're under the legal limit and that belief was reasonable. So it may be applicable where you could show that your drink was spiked and you thought you were fatigued. However, it should be said that it can be very difficult to succeed in a defence of honest and reasonable mistake in high-range drink driving cases. Less common defences include necessity, that is, where you are trying to escape an emergency situation, and duress, where you are forced to drive.